ATM leader, Vuyo Zungula, to reflect on this. Maybe before we get into that conversation, of course, we are coming in this evening, Dr. Zungula, with the news of the passing of one of your colleagues in Parliament, Tina Yomat Peterson. From the ATM's point of view, maybe you would want to reflect on your own tributes.
As the ATM want to send our deepest condolences to her family, including her organization, which is the ANC. May they find comfort during this difficult period.
And let's talk then about the delays that we have been seeing, particularly when it comes to the Section 194 inquiry. Today, reports of yet another delay and the letters that seemingly have been going back and forth between the legal teams of Advocate Mkhwebane and the chairperson. What are your thoughts around what you're seeing emerging there? Seemingly the chairperson is complaining about, for example, last-minute communication that is coming, that the sitting will not be possible because of the legal challenges that still remain.
Look, the attitude of the chairperson has been very clear from the onset that he has a hostile attitude towards Advocate Mkhwebane. Even this process, from even before it started, Advocate Mkhwebane had to fight for her to get legal representation during the course of the proceedings of the inquiry, which is something that ordinarily she would not have needed her to actually fight for, because it is a guaranteed right in terms of our constitution. It is common law, it is common practice that if you are going to have an inquiry that either would lead to a person being removed from an office, it's basic knowledge that you need that person to be afforded legal representation. But she had to fight up until the Constitutional Court for her to be granted such. Therefore, what we've been calling for as the ATM, even when the inquiry was starting, that we do not need as a country an inquiry that is, or rules of parliament that are targeting one individual. We need to have a parliament that is institutional in the sense that it thinks about what is best for the country and it operates on a principled basis, not on a personalized basis whereby there are rules that are designed for Advocate Mkhwebane. Now, if you look at the proceedings and the actions of the chairperson, Mr. Janji, it clearly shows that this is a person that is wanting this inquiry to go towards a particular direction. That is why you find that they've been having a lot of conflict with the senior counsel on issues that they should not be having such conflicts. So our view as the ATM is that you need Advocate Mkhwebane to go back to her office, finish her term there, because clearly this inquiry is nothing more than an attempt to want the people that are doing what the Constitution requires to be removed from these offices, so that the people who are doing wrong things in our country can simply get away scot-free without being held accountable. So our view as the ATM is that this inquiry from day one, it has been clearly been shown that it is a witch hunt. It is something that is done to persecute Advocate Mkhwebane for the sterling work that she's been doing, and most importantly, for the fact that she's able, she does not cower to political interference. She does her work in line with what the Constitution dictates. And the recent media publication about the extortion claims, imagine a country whereby members of parliament actually extort from the husband of Advocate Mkhwebane for her to actually receive a fair trial. CEP, we cannot operate like that. So that is why our view, let her go back to the office, finish her term, do what is right in the Constitution, because that will send a very strong message that people who do their work in line with what the Constitution requires are going to be protected. But if this witch hunt is going to continue, particularly in the way in which it is continuing, then our institutions are being destroyed, and political interference will be the order of the day, and we'll never have a country whereby the rule of law reigns supreme.
Yeah, availability of funds has also come to becoming an issue at this particular point in this scarce environment of money that we are currently operating under. What do you make of the Public Protector's Office limitation of 4 million rands that has been ring-fenced for her further representation?
Look, Advocate Mkhwebane did not suspend herself. Even the High Court in the Western Cape shown that that suspension was unlawful, and the President did something, acted wrong by suspending Advocate Mkhwebane. She did not ask to be brought about to this inquiry. And if you check that letter from the President that was suspending her, it was very clear that she will be afforded the same rights as if she's in office, meaning when it comes to legal representation, the budget should be made available so that she's able to defend herself. Now, the 4 million, it is insufficient in our view, because you can't ring fence only 4 million. Because you don't know, because there have been delays in the past. If you check the inquiry in accordance to the first plans when it started, it was initially supposed to have continued for about 3 months, but we're looking at more and more months. And you have also other cases that are court cases that are currently in court that are also linked to the inquiry. Therefore, 4 million, it is not an amount in our view that is sufficient. Instead, the people should have been, the Advocate Mkhwebane should have been given, enough money so that whatever the needs for her to be represented are enough, but not a case whereby you are saying only 4 million, because what happens when that 4 million runs out? Yeah. And this should not be about money per se, but about the principle that people who occupy public office, whenever they go to court using the state resources. Therefore, the notion that is out there currently, it is as if Advocate Mkhwebane is the only person in public office that is using, the state coffers for her legal representation, whereas it is done by ministers and other Chapter 9 institutions.
You, of course, would be very much aware of the millions that have already been accumulated in this particular inquiry to date. Are you saying it's reasonably acceptable that those fees should continue to be rising unabated?
Look, if you're to look at the evidence leaders, it's a pity that the information that is out there regarding the costs that have been spent on the legal presentation of Advocate Mkhwebane are the only ones that are public knowledge. But there's no question as how much has been paid to the evidence leaders there. Put aside this particular inquiry, if we can ask the other legal processes that are done by people in state institutions, has there been any investigation or any information that is coming to the public knowledge to say these are the amount of costs that have been, incurred by state institutions when it comes to legal fees? So you can see, Butabo, here, even the information that is put there out in public is there to influence and to create a narrative that we've got a certain Advocate Mkhwebane who is wasting the money of the state when it comes to legal representation, whereas there are no questions that are asked about the evidence leaders who have been part of the process since day one. And I can presume if the amount of money that have been paid to Advocate Mkhwebane and the team, I don't think the amount of money paid to the evidence leader is far off. And even, if we were to look at that from a principal perspective, would agree that this is a necessary inquiry in the sense that it is necessary for Advocate Mkhwebane to be cleared that indeed she is fit for office, and at the same time, her being afforded legal representation is also necessary. And it is by the state's way of operating, because it is a state that also funds when ministers go to court. It is a state that is also funding the evidence leader. So there should not only be a focus on the money for Advocate Mkhwebane, but we need to have a holistic approach when it comes to dealing with the issue of money that has been spent for legal reasons by public officials.
Yeah, you already mentioned the evidence leaders, money spent there, money spent on the defense, or at least on the representation of Advocate Mkhwebane, the time spent, yourselves being in Parliament, and the time that has been spent there. You believe you could just drop all that and just close the chapter as if nothing happened and send the public protector back to work? What about all that? Would that not consider or be considered as wasteful expenditure?
Look, Butabo, firstly, it is a motion that has been brought by the DA to say Advocate Mkhwebane is not fit for office. But if you look at the testimonies and the evidence that have been presented, it paints a different picture. Particularly if you look at the other information that has been coming up recently, the recent extortion claims of 3 ANC MPs against the public protector to say, give us a certain amount of money so that we give you a fair trial. That on its own should warrant even the speaker to intervene. Any person would say these are serious allegations because they dent the image and the credibility of the process. And the fact that this is also the backdrop of the suspension of Advocate Mkhwebane being declared unlawful. It's been more than 6 or 7 months now after that court order that was declaring that it is unlawful, but it has not been reversed. Therefore, it is our view as the ATM that the inquiry can still happen, but she must not be suspended. She must be in office and let her do the work that the Constitution requires of her, because firstly, the conduct of the chairperson and the evidence that is there clearly shows that there is nothing wrong with the capabilities of Advocate Mkhwebane. And the most important issue, it is a court order that is saying that the president acted unlawfully by suspending her. In terms of that particular court order, it means that the president acted in a way that should not be tolerated in our country by removing a person that was investigating him. So, based on that, Butabo, she should be in office and let the inquiry operate kakuhle, but not her being disadvantaged by being removed from office via an unlawful suspension.
What do you say to this? The chairperson saying, in respect of the assertion that the committee refused to disclose the rates of evidence leaders, this is not true, and it's not clear how you have arrived at that assumption or who provided you with such false information. Procurement is the domain of the Parliamentary Administration, and Secretary to Parliament is best placed to answer questions relating to the same. However, the question is moot, as the evidence leaders' rates have previously been shared with the Parliamentary Communication Services with the media on request, and the fact was published by the media, saying that those fees are quite out there. It's not a secret.
Look, Butabo, anytime there's a discussion about the legal fees of Advocate Mkhwebane, especially when there is that notion that she's wasting money, you find that the discussion is not done in comparison to the evidence leaders. The discussion is always been focused on her. Whereas if there was any sort of principle, there would have been a discussion that is saying this is how much that has been paid for the legal representation of Advocate Mkhwebane. This is how much has been paid to the evidence leaders from a comparative point of view, not a case whereby Nicodemously somewhere in the background there's going to be a Media Communication Office of Parliament that will Nicodemously release that type of information. But when the discussion is about how much has been spent on the legal representation, that information is nowhere to be found. Because, look, legal fees of Advocate Mkhwebane, I remember one time they were even trending on Twitter because it is something that was even brought about to the attention of the committee, discussed in a committee sitting. But when it comes to the evidence leaders, there's never, such a thing has never happened. So that is why our argument is a comparative point of view to say you can't be speaking about Advocate Mkhwebane legal presentation, but you, especially when you are saying that these costs are going unabated, but you say nothing about the cost of the evidence leaders.
And in your view, I mean, this particular matter should have been wrapped up at this particular point, or at least before the term of office of the public protector. If it goes on further than that, what would be the point of continuing with the process?
Look, it's what we've been stating all along to say, number one, Advocate Mkhwebane sits here now being unlawfully suspended. That should be a grave worry to each and every South African who aspires to live in an ethically governed country whereby your presidents act in line with the law and they do not suspend people that are investigating him. Secondly, the extortion claims very, very serious, because you want Parliament Butabo ought to be an institution whereby all South Africans have got that confidence that this institution acts in the best interest of the people, and you can't have an institution that ought to play an oversight role over Chapter 9 institutions and the executive being at the center of corruption allegations, especially of this nature, especially of an inquiry as serious as this one, whereby a person is alleged to be unfit for office. And the other issue is the evidence that has come out during the course of this inquiry clearly shows that we've got an inquiry that was not about the best interest of the country in any case, but it is an inquiry that came from the DA, a DA that clearly stated even before Advocate Mkhwebane started her term of office that they hate her and they hate what she represents, and they hate that they've got someone in that office that is working and doing her work in line with what the law requires. You'll recall they went as far as even calling her a spy, and they've made wild allegations which even today they are not tested. So what we do not want as the ATM, we do not want the hatred of the DA for an African woman to be used in a manner that this parliament now has been having a trial or inquiry for so long, wasting so much money for something that is not there, because the DA did not bring about this motion based on pure reasons, but they will bring about this motion based on hatred that they've clearly been showing even before Advocate Mkhwebane started the first day in office.
Vuyo Zungula, I appreciate your time. Thanks so much for coming on tonight. That is ATM's leader there, Vuyo Zungula.